Welcome to the Probate Nation. People are living longer thanks to good health care and healthy lifestyles. Yet as we age, not everyone remains as sharp as they were earlier in their life. Frequently, a loved one, a son or a daughter is called upon to take on the responsibility of helping an elderly parent with their financial and medical decisions. But even more frequently, and unfortunately, the parent has not executed key legal documents to formally authorize that assistance. In part one of this program, we learned about the legal process you can initiate to acquire that legal authority as a court-appointed guardian and conservator if your parents live in Fairfax County, including bonding requirements, what needs to go into the pleading to the court, the role of the guardian ad litem, and the court hearing to act on your request. But what was covered in part one is not the end of the story. Tonight in part two, we complete that discussion. We are fortunate to have back as our guests, again, local attorneys with experience in these matters. They will serve as our guides in completing the discussion about all that is involved in the living probate train ride you are seeking to embark on. Our first guest is a founding partner of the Fairfax law firm of Cuccinelli Geiger. Her practice focuses on estate planning, probate, and adult guardianships. And she serves as a certified guardian ad litem for incapacitated adults. She is a member of the Fairfax Bar Association and the Northern Virginia Women's Attorneys Association. She is a member and past board member of the Virginia Academy of Elder Law Attorneys and currently serves on the Board of Governors of the Virginia State Bar Trust and Estate Section. Our second guest is a partner in the Fairfax law firm of Yates, Campbell & Hogue. His practice focuses on estate planning, estate and trust administration, fiduciary controversies, tax matters, and tax return preparation. And he also serves as a certified GAL for incapacitated adult. He has been a Virginia Steeley presenter and a presenter at conferences held by the National Academy of Elder Law Attorneys and the Virginia chapter of NALA. Please welcome back attorneys Carrie Cuccinelli and Mark Christopher. Guys, welcome back. Thanks for coming back for the second part of this program. You know, Mark White, we've done a lot in part one, but it seemed like there's a lot of lawyer time involved. So there's a lot of fees and costs that can arise in this process. So I want you to talk about who pays for these fees.
Typically, the individual, the respondent, his estate will pay for these fees. The fees will involve the cost of the petitioner's counsel, the cost of the guardian ad litem, and the respondent's attorney if the respondent has one.
Okay. But to start the process, though, typically the petitioning attorney will have to be retained by the petitioner out of their own pocket. Is that true?
Yes, oftentimes that attorney may initiate the proceeding without a retainer.
Okay. Well, at the beginning of the part one of this show, we talked about some key legal documents that folks should be sure to execute. These are documents that might eliminate the need to embark on this living probate train ride we talk about. Can you mention those documents again?
Yes, the power of attorney, the general power of attorney, is used as a device to manage the property of the individual. The advanced medical directive addresses that person's care, medical decision-making, and decisions about end of life and so forth.
You know, these days, Mark, everybody is being especially cost conscious and thrifty, and those are good things. In your experience, would you estimate the cost of preparing those very basic estate documents you just mentioned, the power of attorney for finances, medical decision-making document? Are they going to be more or less than the costs and fees associated with actually going to court to get formally appointed as a guardian and conservator?
They're typically much less. A power of attorney and a medical directive are usually prepared as part of an estate planning package, and are not particularly expensive to prepare.
That's good to know. I think that's important for folks to keep in mind. I urge folks to give that some thought and take some action to to get ahead of the curve if something should happen to your parents or to yourselves. But let's continue our discussion. We've been to court. The court has ruled on our petition. We know that our authority has not yet been conferred on us, that we need to go to the probate office to complete the process. So Carrie, with the court order in hand, can you head over to the probate office in Fairfax and get appointed as guardian or conservator that day?
No, not that day. Right now, because of the pandemic, appointments with the probate office have to be made subsequent to the court hearing. Typically, we're looking at 2 to 3, maybe even 4 weeks until an appointment can be had.
And I think that's important for folks to understand that this process is somewhat extenuating. So and the process to actually get that appointment and actually have it completed, there are a series of steps that need to be taken in order to get that qualification appointment. Can you just kind of walk us through that a little bit so folks understand what they're going to be they'll be encountering?
Sure. We obviously do this on behalf of clients, but the first step in the process is to call the probate office and inform the office that you need to qualify or that your client needs to qualify. In response, an email will be sent to the person who is going to upload information to what's called share file. And that information is reviewed by the clerk there in the probate office. And subsequent to that review, a phone call will be made to the individual who needs to qualify to go over any questions that might be outstanding, documents that might still be needed to be provided, and an appointment is made. After the appointment is made, another email is sent with a link to a WebEx meeting, and that WebEx meeting is had, so it's a virtual meeting between the guardian/conservator and the probate clerk.
So one of the forms, though, that I think that has to be uploaded in advance is called an adult information form that they ask you to complete and turn in. So but you do need to have access to a computer. You do need to have access to a computer with a camera, because eventually they're going to have to be able to see you, as I understand it. Is that correct?
That's correct. During the qualification meeting, the probate clerk will actually, I've had meetings recently where the probate clerk asks the guardian or conservator to hold up to the screen his or her driver's license so that it can be seen, as well as having the individual who is qualifying sign through email, through an electronic signature, the forms that would otherwise typically be signed in person.
So I think this particular process is something that's going to be with us for a while, I think. So folks ought to be prepared for it. For conservator appointment, we discussed the need for a bond to be issued by an insurance company. So will that bonding representative or agent need to be present virtually when the conservator is appointed?
No, not in Fairfax. In Fairfax, the representative from the bonding company will provide that information is provided to the bonding company in advance, as we talked about in part 1. The appointment finalizes the process of qualification, and the paperwork is provided to the bonding company after that qualification appointment.
So let's just talk for a second, though. How the court order that we're going to talk about actually will identify what the bond amount is going to be. So how is the bond amount determined?
In Fairfax, as we talked about in part 1, typically I've actually never known it to be anything other than a $1,000 bond, unsecured for guardians.
Okay.
For conservators, the bond is set at 1 1/3 the value of the assets over which the conservator will have control, plus the value, the annual income of that individual respondent.
So, and of course, obviously, we do the best we can as far as values at the time, but that can be adjusted once we get more information. So what type of document is given to the petitioner who's now going to be a guardian conservator that shows that they now have been officially appointed?
Right. The guardian and conservator will receive, if it's one person will get 2 certificates of qualification, one for their role as guardian and another as their role as conservator. And that certificate of qualification is just a piece of paper with a raised seal, but it is their, as I term it, their driver's license as guardian to do what they need to do and what authority they've been provided under the court's order.
So does the probate office provide any written guidance or instructions to the appointed guardian or conservator?
Yes, pre-COVID, it would be handed to them at the time of the appointment, but now those packets of information are mailed to the individual who has qualified. It's very helpful information. It's a guide to how to do your job as guardian and conservator.
Very, very helpful. Now, before I leave the probate office, I wanted to ask you though, what are some common reasons why the qualification cannot proceed?
Typically, there is some problem with the order. Again, pre-pandemic, we would go down to the probate office and the order would be presented to the probate clerk, and any issues with the order could be addressed immediately by going back to the courtroom and having those issues fixed by the judge. Now we have an issue where the court order makes its way down to the clerk's office several days after the hearing, and so the lag can be considerable to get those kinds of issues fixed. It can be anything from a failure to include a term, finding the individual incapacitated, which obviously is very important, which is why I said in part 1, the importance of the terms and the language in the order is paramount.
Right, and I know there's a recent statute that went into effect last July that actually says you have to have certain font sizes and boldness in certain things, and if that's not done, which a lot of people don't realize, and certainly a pro se applicant may not realize, then that order will have to go back up to have it done correctly. Is that true?
That's exactly right. Yeah, it's been in place since last July, and to the wary, or the unknowing, folks who don't know can certainly be caught unawares by not having 14-point font of certain language that is required to be included.
Mark, I'm going to turn to you now. We're going to talk about some of the reporting requirements after appointment. So after being qualified, in the probate office, the guardian and conservator does have some ongoing reporting obligations, both to the Department of Social Services and the Fairfax County Commissioner of Accounts. So Mark, what are the reporting obligations to the Department of Social Services?
The first is that there is a report of the guardian that is a 2-page form. It's basically a narrative that details the contact with the individual, explains their circumstances, where they're living, the care plan, and the person's residence, and whether or not the guardian continues to agree with the person's circumstances.
Okay. And how often is that, when is that first filing due, and how often do you have to file that?
The first one is due 4 months after qualification. And then after that, they are filed once a year.
Okay. And I know there's a small fee that goes with that, but it's not very much.
No, that's right. It's very minor.
Now, let's talk about the reporting obligations to the Commissioner of Accounts. That is often what gets a conservator in trouble and leads to their removal or to lawsuits against them. So can you review some of the key do's and don'ts that every conservator should follow in order to make sure that they do things appropriately for the commissioner?
Yes. There's an inventory that is filed 4 months. after a qualification. The purpose is to detail the property of the incapacitated person. Interestingly, it doesn't have entries for the person's liabilities. The inventory is filed with the Commissioner of Accounts. It's actually not audited. If it's in good form, it will be accepted. And then subsequent to that, there's going to be an accounting. The first accounting is filed 6 months after the person has qualified, and it covers the first 4 months of the term of the conservatorship. The accounting covers every penny in and every penny out.
So I think the one thing I think we want to emphasize, and I think you made a good point about this, the inventory is in effect the opening entries of your financial obligations to this particular respondent, but it's not supported by any documentation. So it might, at first blush, seem like it's a fairly loose reporting process, but once you file the accounting, everything you receive, everything you disperse has to be documented, doesn't it, Mark?
Correct. These accountings can be very complicated. Each account has to have copies of the statements that tie down to the penny what we began with and then what happened to the assets.
But one of the things that a lot of people don't do, but they are told to do, I know the commissioner makes a point about this, is that when you first get appointed and you take over the assets, what account do you do the banking from? In other words, do you just continue to use the bank account of the respondent, or do you need to go set up your own checking account as conservator?
Typically, banks have an approach where you can register as the conservator using the same account number.
Okay.
And the reason why this is because when you have a conservator, the ownership of the account does not change. In other words, if I'm the conservator for Fred still owns the account after I'm his conservator.
That's true. Now, one of the things I know is very important in the accounting process is to make sure you get copies of those checks. So I guess you need to make sure the bank is going to produce those paid checks as part of the statements they get you. Is that important?
Yes. There are 2 ways that this is usually done. One is to, as you said, print out the checks so that the commissioner can see each one of them. In addition, or as an alternative, the bank may provide you with statements that have miniature images of all the checks that are clearing the account.
Good point. Now, I would like to pass along to our audience, both of these particular filings with the Commissioner of Accounts, both the inventory and the accounting. The accounting form seems really innocuous. It's basically 10 lines, and you would think that that'd be easy enough to do. But not surprisingly, it is a source of great consternation. I will say we've done some prior shows for our viewers that were hosted by, we had guests on who were former auditors with the local Commissioner of Accounts, Fairfax Commissioner of Accounts. And they talk about the preparation of the inventory in a conservatorship and the preparation of the accounting in a conservatorship. Those shows might bear worth watching, even if you're going to hire somebody. It gives you a better understanding about all the complications and nuances that occur in preparing and filing those 2 filings. Okay, so let's go ahead and turn to the next topic, which is the common problems and pitfalls. So we've now gone through the part 1, and we're pretty far along in part 2. So let's talk about some of the common problems and pitfalls that you see now at this stage in undertaking to be appointed a guardian and conservator. So Carrie, would you share some of your thoughts?
Sure. I'll follow on what you just said about the importance of the inventory and the accountings. Obviously, they're important. I highly recommend and always encourage clients to engage the services of a professional to do those inventories and accountings or inventory and accountings for the conservator. A lot of folks don't have experience doing this, and they can just get themselves into a lot of trouble, not because they've done anything wrong, but because they didn't understand the accounting procedures of the commissioner's office. That would certainly be something that I would highly recommend. A lot of folks think, well, this is easy. I'm an accountant. I know how to do this. But it's a different kind of animal, and I would highly recommend engaging professional support.
Mark, how about yourself? Anything else at this point as we've worked our way through the qualification process and we're now getting ready to board the probate train? Some things you would give people advice about?
I think it's important not to once you are the conservator, you ought to understand what the individual owns. Get a copy of the person's tax return and all of the backup to it, because those statements will oftentimes tell you what are the accounts that this person owns. In addition to that, you have to know what they owe. So you have to watch the mail and keep all the statements together. Look at any mail that's coming in that is coming from a creditor. And you can also run the title on the person's house. Sometimes we have to look for issues of financial exploitation, for example.
Okay. So, clearly now we've seen this. There are a lot of moving parts in this process, and these two programs, Part 1 and Part 2, really only scratch the surface as to all that goes into making the process work, And of course, every family situation presents its own dynamics and challenges. So again, I hope our viewers appreciate that this is a process that should only be initiated with the assistance of legal counsel. It is really not something you should undertake to do on your own. So, Carrie, Mark, I'm going to come back to you for some final thoughts, words of advice, practical suggestions regarding obtaining appointment as a guardian or conservator of an adult in Fairfax County. Carrie?
I think I'd like to go back to how you started the program, which was by talking about the documents that an individual needs in order to ensure that if they're incapacitated, there are others who can step into their shoes and make decisions for them. By doing that fairly simple thing, they can help their family to avoid what can be a very painful and expensive process. So I think I would simply challenge everyone who's over the age of 18 to make sure they have documents that will ensure that they have agents named to step into their shoes if they're not able to act for themselves, so that their families can avoid this kind of situation.
Okay. Mark, how about yourself? Any final thoughts, suggestions, words of advice?
I second what Carrie has said. I think it's important that if there is going to be a controversies, to have a family meeting for her and see if we can build a consensus with all the family members as to what's going to happen.
Well, those are all good suggestions, and I want to thank both of you for taking the time again to participate in Part 2 of this program about attaining a guardianship or conservatorship for an adult in Fairfax County. Great service to our community, and I appreciate you guys sharing your expertise. So, if you need to petition the Fairfax County Circuit Court for the legal authority as a guardian and conservator, what our guests shared over the course of 2 shows should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirements both in the documents filed and in decisions to be made, many of which involve seeking help and guidance from other professionals. My guiding concern as we wrap up these shows is the following. Seeking this authority is not an undertaking you should handle as a pro se petitioner. There are simply too many decisions to be made, too many legal steps that require legal knowledge, and often this is an emotional time for the family, for you, and the person you are seeking legal authority to care and act for. I urge you to seek out the assistance of an attorney with expertise in these matters before you get in line to purchase a ticket to board the Living Probate train. You'll be glad you did so. This brings us to the conclusion of our show. I hope it was informative. And remember that replays of both these shows and all shows to date can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.